Good morning, sir. Is it Jerron or Jaron?
Jerome.
Jerron Crane. And Mr. Crane was previously in court, entered pleas of guilty in cause numbers 23 DCCR 1406 and 23 DCCR 2233. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Judge.
Have your honor. Any additions or corrections?
No, Judge.
Judge, only just to refresh the court's recollection that the co-defendant is Mr. St. Clair.
Yes.
Dealt with him last week. Also, Mr. Crane has been on house arrest and I think it has had no issues while out of bond. So we ask court to consider following. Great.
I don't have any problem following the agreement. I am, however, going to require, based on age, nature of the offense, and some of the things that he said, particularly with regard to being young and being a follower, the ISF cognitive track. And that is not intended to be necessarily a punishment, but some tools to get you in the right spot so that you can be successful in this probation. So let me go through all that and then I'll explain some more. So I'm going to find in each of your cases, Mr. Crane, that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, I am going to follow the agreements that you made with the district attorney's office. In cause number 23 DCCR 1406, I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. And I'm going to go over some of those in just a minute. And then in cause number 23, DCCR 2233, I'm also going to find sufficient evidence to find you guilty. However, I'm also going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay that $500 fine and again, to follow all of the rules and conditions of probation. So some specific conditions in each case. The first is going to be that you enter and successfully complete the cognitive track of the ISF program. What that means is you're going to go into custody today. There's a short wait. I don't think it's very long, and you'll be transferred to that ISF program. That is a program for you to learn to make better decisions. You're very young. This opportunity that you're getting today is literally the opportunity of a lifetime. And what happens if you don't take advantage of it is you could end up spending a lifetime in jail instead, or prison, because the range of punishment on this, if you violate your probation, is between 5 years and up to 99 years or life in prison. So I want you to have the tools to be successful. But here's part of that. You're going to end up in jail with some of the same people that I really don't want you to be around. And so we're gonna send I'm gonna send something over there to the jail so that hopefully you guys can be kept separate. Because if you get in trouble, part of your condition of probation is that you not get in trouble in jail. If you end up with incident reports while you're in jail or while you're at ISF, then that means that you've already violated your probation before you ever get back out again. So whatever you need to do to take advantage of that opportunity that you're being given to stay clean and out of the way in jail, you're not the only one in there that has been given this same rule and same consequences if you violate the rules. So y'all need to get together and go, I don't want to go to prison for a long, long time. All right. You will be required to get your GED as a condition of your probation. That's to help you. So as soon as you get out of ISF, and I'm not sure, you might even can start that while you're there in ISF. But if you can't, then when you get out, you're going to start it within 30 days. That's a requirement. And you obviously cannot have any contact communication with Aleem St. Clair or go on the locations of 9390 Doty Street, 6817 Terrell or Terrell Street. You can't have any contact or communication with the victims of these offenses. And there's just going to be regular show up for probation, all of those types of things. Test negative, you cannot use any drugs. That if you do that, again, I want to really, I hope you understand, and I'm sure Mr. Gertz has gone over this with you, the opportunity that we're being given today. And I want you to do well, and I want you to be successful. But I want you to understand that if you're not, then I'm going to look back, if you're here on a motion to revoke, number one, at the underlying offenses and how serious they are. And the fact that you got this opportunity, you're not going to get another chance and come back in and go, well, I just messed up a little. Give me another chance. This is your chance. Okay. So take advantage of it. Also, condition of these Probations is that you cannot possess a firearm of any sort. You can't have it in a car. You can't be with other people that are possessing firearms. If there are firearms in the house where you live, they have to be under lock and key or out of the house where you don't have access to them. Do you understand? All right, I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed. And so you've waived your right to appeal. I will sign that dismissal and cause number 23 DCCR 1082 as part of this deal. And then you can go back with the bailiff. Good luck to you, sir. Good morning, sir. Are you Aaron Wars?
Yeah.
And Mr. Macon, will your client waive the formal reading of the indictment?
Yes, sure.
Mr. Wars, in cause number 25 DCCR 1253, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's from October 26th of 2024. Your indictment alleges you were previously convicted of driving while intoxicated March 27th of 2018, and then again May 18th of 2023. And how do you plead to that charge?
Guilty.
And are those two prior convictions true?
Yes.
And did you enter your plea of guilty and true freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents and have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Macon? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 10 years. You would have a $500 fine and be required to follow all of the rules and conditions of probation.
Yes. 10 days in jail starting this Friday.
I have to sentence him. He has to be sentenced.
Yeah.
I can't sentence him today. I have to get a pre-sentence
Oh,
report.
okay.
So the 10 days will have to be after that pre-sentence
Yeah.
report. It's mandatory, but
Yeah.
it won't start this week. So what'll happen, is that your understanding of your agreement though? Okay, and we'll talk about the 10 days in just a minute. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, John.
It's admitted. Is there any evidence that Mr. Wars is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Do you have, as a condition of your bond, the auto ignition interlock device on your vehicle?
Thank you.
So you're not driving? Okay, I do want to make sure you understand that if you get a vehicle, you cannot drive any vehicle unless it has that auto ignition interlock device on it. You understand? Right. And then that 10 days, again, when you come back for sentencing, that's when you'll either start it that day, or if you're working, then I would consider starting it a different day that weekend or something like that. So we'll talk about that at sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there. Okay, we'll see y'all back at sentencing.
Okay.
Good morning, you're Anthony McFarland. And Mr. McFarland, did you get someone hired?
No.
Did you talk to some lawyers?
Yes, ma'am.
Who'd you talk to?
Aldrin, Samuel,
Mm-hmm.
Ryan Gerson, Benjamin Jeffries.
Okay, where are you on being able to get someone hired?
I just got hired at Motorburger. So
Okay.
I'm trying.
All right, so thank you for doing what I asked you to do. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it. If you step down to the clerk on the end, she'll give you that paperwork. Good morning, sir. You're Brad Thibodeau?
Yes.
And Mr. Thibodeau, did you get someone hired?
Now I've got 3 reference.
Did you talk to some lawyers?
Yes.
Okay, who'd you talk to?
Joe, Vasquez, Willard, Hall, and Roy. John Hampton, been away.
Okay. And where are you on being able to get someone hired?
Well, I'm currently employed.
I'm sorry, I can't hear you.
I'm currently unemployed.
Okay, when's the last time you worked? Aren't you working?
I'm not working
Uh-huh,
because I'm taking care of my mother's.
okay. And,
It's bad here from perhaps I rest.
okay, you need to get a job. And so, and I'm going to reset your case one more time. You've been coming. I guess that you've been here once. So you need to try to get work between now and that next court date. All right, bring me proof of where you have applied or bring me proof of the fact that you've gotten a job. Talk to some other attorneys as well, and then we'll see where we are at the next court date. All right, step in front of the clerk. The expunction on, near Benur. Good morning. So this is 26 DCCV 0328. Mr. Gertz has filed a petition for expunction and looks like the state has filed a general denial.
As well as
And-
DPS.
I suspect DPS isn't here, but Judge, I assume Mr. Coleman wants, is continuing in the position that he's opposed to this.
I'm sorry?
I said, I'm double checking with Mr. Coleman to make sure that you're still opposed to this. Okay.
Yeah.
Well, Judge, what I'm gonna do, I think that the DPS filing, even though I think DPS isn't here,
I
is
don't even
probably,
see-
I just read it this morning, Judge, but
I have a copy here if you like, Judge.
Yeah, it's not in this file.
it's
so-
probably more accurate. And I think given that objection, what I'd like to do, instead of having you deny it based on a hearing, I'd rather withdraw our petition at this time
Okay,
and postpone it to a more correct date, if the court will.
there you go.
Uh,
All right, so
and
if
then-
you'll just, if you'll file something withdrawing that, we'll get that done and then I don't need to, I won't sign anything denying it.
Okay.
Okay,
Thank you.
perfect. Thanks. Good morning. Are you Calvin Smith? And Mr. Smith, this is your initial appearance and cause number 25 DCCR 1639. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from September 30th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right, so when, same as you've heard about me say, when you're in custody, we give you a court-appointed attorney, but once you make bond, I expect you to try to hire your own attorney. So I'm gonna reset your case for about 30 days to give you some time to hire, get someone hired. If you do get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, I just see that you have another case, don't you? You have also the burglary of a building. From that same date of September 30th of 2025, and that's cause number 25 DCCR 1638. So you've got two cases. So anyway, so try to get a lawyer hired. If not, visit with at least three. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers you talked to when you come back, so I know you're trying. And then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bonds for not following the court order and you go back to jail. Do you understand?
Yes, ma'am.
All right, if you step in front of the clerk, she'll give you your reset notice. Good morning, sir. Are you Derek Wells? And Mr. Wells, this is your initial appearance and cause number 26 DCCR 0216. You're charged with the third-degree felony offense of obstruction or retaliation from February 3rd of 2025. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
Yes, ma'am, but he's not present.
Have you already hired him or you intend to?
Yes, he's hired.
Who?
Right, can I?
When did you hire him?
Yeah. It's been a good 6-7 months. I met with him a few weeks ago at his law office.
Hang on, huh? Okay, so we don't have a letter from him showing that you've hired him yet. So what I'm going to do is just reset your case a couple of weeks. Make sure you get this reset notice that you get today to Mr. Kimler's office this week so that they can file the appropriate paperwork to show that they've been hired, okay? Step in front of the clerk. Good morning. Are you Claire Desabille? And Ms. Bill, this is your initial appearance. In clause number 26, DCCR 0224, you're charged with the third-degree felony offense of unlawful carrying a weapon on alcohol premises or a premises that serves alcohol, and that's from October 25th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right, so what I'm going to do, Ms. Bill, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Yes.
All right, if you step in front of the clerk, she'll give you your reset notice. Good morning. Are you David Calderon?
Yes.
And Mr. Calderon, this is your initial appearance in clause number 24, DCCR 1428. You're charged with the state jail felony offense of unauthorized use of a vehicle, and that is from May 20th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am. I'm actually, been out probably like 2.5 weeks already. So.
Out of jail?
Honestly, yes.
Oh, yeah. Okay. So what I'm going to do then, Mr. Calderon, is reset your case for about 30 days to give you some time to try to hire someone.
Yes, ma'am.
If you get a lawyer hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
Step in front of the clerk, she'll give you your reset
Can I ask you a
notice.
question?
Yes, sir.
Drove 2 hours to get here, and by the grace of God, I made it here. I don't have transportation. I was wondering, is there any way this can, like, I can do this through like Zoom?
No,
No.
you have to come in person.
Okay.
Yes, sir. Good morning. Are you Vicente Gloria?
Yes, ma'am.
And Mr. Gloria, this is your initial appearance in clause number 25, DCCR 1822. You're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. And so since you've made bond, have you had an opportunity to hire a lawyer?
No, ma'am, I was not aware. I thought it would be.
Sure, right. So you've heard what I've said. I'm going to
Yeah.
reset your case about 30 days so that you can try to get someone hired. You're going to get a reset notice today. If you hire someone, bring it to them. And they'll tell you what to do. If you're unable to, then I'm ordering you to visit with at least 3. They all charge different amounts, different payment plans. Bring me the names of who you've talked to so I know you're trying, and we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you step in front of the clerk, she'll give you your reset notice. And you are Austin Talbot?
Yes, ma'am.
And again, this is 20-35335. There is a motion to revoke Mr. Talbot's unadjudicated probation. And what is the announcement?
Oh, Your Honor, at the time that Mr. Gomler was still working for the discovery office, wanted to make a progress. It should be here the next day, reset.
Typically, Judge, we don't do discovery portal on motions to revoke. I did
I think
speak.
he's working something on the side.
Okay, I didn't know if maybe you guys were also representing him in Tyler County on the new DWI.
Don't believe so.
Okay, and I reached out to Ms. Broussard, she's here, Judge, last week. She has a probable cause, but it's our understanding that that case has yet been filed.
It hasn't been filed as.
Okay.
It would probably, if the court would allow, be a little bit more beneficial for me if you would just go through the motion, but if we want to do that next time with Mr. Galmore, that's fine. I just need to know if I need to get moving on that out of county.
Right. Let's do this. I'm gonna just do maybe a 2 or 3 week reset since he's on probation. So
Yeah.
we can go ahead and get pleas on that date. If true or not true, then we'll know where to head if we need a hearing on the sentencing or not. All right. Okay. Stay in touch with your attorney. So I'll let you know when you need to be back. Thank you for being here.
Thank you, Judge.
No problem.
I believe he has one more.
That's all I'll show for him here.
Yes.
Uh-huh.
Okay, thank you.
Yes, ma'am. Thank you.
Judge John Richard from earlier on the
Uh-huh.
initial, he's in the box.
Good morning, sir. You are John Richard.
Yes, ma'am.
And Mr. Richard, it's very important that you're on time.
Yes, ma'am.
In the future, I'm going to recall that bond forfeiture. And Mr. Richard, did you get someone hired?
No, ma'am. They told me to do the job thing, try to find the jobs, and these are the places that I had went to. They haven't contacted me back about an interview, and
Okay, where have you gone?
The Elegante Hotel
Mhm.
and the Hilton. I went to Chubby's Paint and Body Shop, Zumos. I did the Zumos online, Polycon online, and Collision online.
Okay, great. Thank you for doing what I asked you to do, Mr. Richard. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure and fill it out accurately and completely because you'll swear under oath that it's all true and correct. And then I'll take a look at it after that. If you'll step in front of the clerk on the end right there, she'll give you that paperwork.
Thank you.
Yes, sir. Mr. Gertz, you have I'm sorry, Jerron Crane, two cases sentencing, 3 cases, I'm sorry. Or Felicia Freddie. I'm sorry. And Ms. Freddie has a motion to revoke her unadjudicated probation. What is the announcement?
Judge, this is based on an allegation involving a new incident. We're still reviewing the discovery from that incident. There's a potentially a problem with the evidence that we probably shouldn't talk about
Okay,
online, but
all right.
but that I'm aware of, and we could just need some time on is my answer.
No objection, Judge.
All right, so I'll just do a normal reset. That'll give you some time to get with Mr. Coleman and get whatever you need on that new offense. And then we'll get an announcement at the next court date. Make sure you stay in touch with Mr. Gertz. Visit with him before that next court date, and then we'll see you back then, okay? Free to go. Good morning. What's the announcement?
Oh, I'm sorry, Judge, we filled out a plea bargain rejection.
I don't see it yet.
It must be in the air.
Okay, all right, let's go through that. So you're Davin Kalina
Yes, ma'am.
and Mr. Kalina, in cause number 24, DCCR 2432, you're charged with a 3rd-degree felony offense of injury to a child, elderly, or disabled individual from September 27th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a document that you've signed with Mr. Kelly. This a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be to plead to the lesser included class A misdemeanor, what, just an assault or?
Yes, Your Honor, just an assault. And if it would probably be refiled. We would
Okay.
put that as the rejection.
Gotcha.
And if we are, I think right now it's best to put it on the trial document. I think we prepare trial very quickly. If for some reason I am able to resolve it with that refile and some pretrial matters, I will do that. It will be off the school stock.
Okay, thank you. And so what the offer is for a 2-year deferred probation. You have every right to reject that and to have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
Yes, ma'am.
And if it sounds like if there is something that gets worked out before that trial docket, then it'll get taken care of down the hall in a misdemeanor court. But I want to make sure you understand if that doesn't work out and you're still on this trial docket, that I won't accept this plea agreement once you're back here and set for trial. Do you understand?
Yes, ma'am. We understand. Judge.
Okay, so I'll get it set on the trial docket. Again, if something works out, just let us know. We'll get it taken care of.
We'll do that.
Right.
Thank you.
Thank you.
Yes, thank you.
Stay in touch with Mr. Kelly. He'll let you know when you need to be back and to which court.
Thank you, Judge.
Okay. Morning, ma'am. Are you Ashley Sanders? And this is 24 DCCR 1650. Ms. Sanders is charged with theft of service. I think we've been waiting on
This is also.
the audit. So everything's done as far as discovery, and now we've got the rejection, correct? So
Yes.
Ms. Sanders, you're charged with a 2nd-degree felony offense of theft of service. And that's from February 1st of 2019, continuing through May 31st of 2023. And what that means, ma'am, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kelly that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be for a 10-year deferred probation. You would be required to pay any restitution back and follow the rules and conditions of probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are, if you understand all of that. And do you want to reject that offer and have your case set for trial? Is there,
Just to be candid with the court so that Ms. Sanders is aware that all.
This is a fascinating legal moment. The theft of service charge spans 4 years, February 2019 all the way to May 2023. The offer on the table is 10-year deferred probation with restitution, and she's rejecting it for trial. The judge makes the stakes unmistakably clear, up to 20 years in prison if convicted. And once that trial docket is set, the plea deal disappears. That door closes permanently unless new evidence surfaces. Bold decision. High stakes.
Obviously contemplated the court's authority to change the length of that and also a restitution hearing of sorts so that we
Sure.
can kind of figure out, if that's an appropriate amount of time, if the court thinks less is appropriate. I just didn't want her to feel. We put it up there at the top to give you that latitude.
and have y'all, would that make any difference? So I do want to make sure that after today, Ms. Sanders, you understand that once your case is on the trial docket, I will not accept this plea agreement unless there's new evidence that your attorney or the state's attorney discovers. Do you understand? And do you want to reject that and have your case set for trial? All right, we'll get it set on the trial docket and Mr. Kelly will begin preparation for trial.
Okay.
Thank you.
Thank you.
Good morning, sir. Are you Sean Dage Jr.? And Mr. Dage is charged with evading arrest or detention with previous convictions and cause number 24 DCCR 2353. And what is the announce?
Your Honor, if we could have one more last announcement. We have seen the videos, we've gotten an offer, but I think there's one body cam that we're missing. I've asked the state for that, but I sent it to the wrong.
Okay. All right, we'll just do a normal reset. You can get with Mr. Smith, make sure you get all that. And then Mr. Dage, make sure you visit with Mr. Lane before that next court date. So once he does get that video, y'all can go over it and we'll get an announcement at the next court date.
Thank you.
All right, you're free to go. Mr. Macon, you have Aaron Wars. Good morning, ma'am. Are you Kelly McBride? And Ms. McBride was previously in court in cause number 25 DCCR 0044. Entered a plea of guilty to the 3rd-degree felony offense of obstruction or retaliation. I've received that pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
Your Honor, there's no corrections that we want to address because of the circumstances around it. We are agreeing and we'd like to move forward.
Any issues?
No, Judge, just to let the court know, she also will enter a plea of guilty to the that was part
Right.
of our plea bargain. So
Okay.
after the court sentences her here, not follow this, she'll go down the hall and enter back. With all of those conditions to be imposed as well.
Thank you. And is that your understanding as well? Y'all will go down and take care of that today?
Yes, Your
All
Honor.
right, then, Ms. McBride, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would have a felony conviction, and you could go to prison anywhere in that punishment range between 2 years and up to 10 years. Do you understand? Excuse me, I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, before y'all go down there, probation will go over your paperwork. And then y'all can go down there, and if you think it'll be a little bit, they can go take care of that and come back. Okay, she's gonna take care of you before y'all go down there.
Now I'm going to take care of Mr. Coker.
Perfect. Thank you, sir.
Thank you.
I'll hold it for that.
One judge, one morning session. Lives changed in real time. From a young man handed the opportunity of a lifetime to a repeat DWI offender facing his last off-ramp, to defendants choosing trials over plea deals. This courtroom showed exactly how the justice system balances accountability with opportunity. The judge never raised her voice. She didn't need to. Every word carried weight. Every ruling had purpose. And every defendant left knowing exactly where they stood. If this breakdown hit home, smash that like button, share it with someone who needs to see real justice in action, and subscribe for more courtroom moments that remind us the law doesn't bend, but sometimes it does give you one more chance.